The lesson for the day is do not say anything in court which you do not understand the full implications, the full consequences of. Ever so often, I come across either in other cases or sometimes in my own cases, some advocate, some party in person who makes a submission before the court that he does not really know the answer to. And the judge also, because of reasons best known to them, perhaps faster resolution, faster disposal, or maybe a quicker way to get an adjournment, the judges also agree. And a lot of times this situation especially happens because the judge themselves have suggested this to the lawyer, and because of this the lawyer or the party in person agrees, and then they later realize that they made this mistake, which is very, very difficult to now get out of. It is far more easier to accept the fool that you are and tell the judge that you do not know what is this thing being talked about, and then seek a passover, which means that the same day itself the matter may be taken up after a short amount of time, or to seek an adjournment, which means ek aur tareekh de dijiye. If you do these situations, the judge will be very, very happy to give you the passover or the adjournment, because they also understand the limitations that comes with lack of years of experience at the bar, or perhaps some sort of general lack of knowledge about the issue at hand. However, if you do the thing which the judge is suggesting you to do without fully understanding the consequences, then it is very, very difficult, way more difficult for you to then set aside the consequences of that. It is better explained by an illustration. A junior lawyer recently reached out to me and said that he made certain submissions before a particular court. The court says, "We are not impressed with your arguments. Please withdraw your petition, else we will dismiss it." The counsel tells me that the judges said, "Please withdraw it or we'll dismiss it." So I thought it is better to just go ahead and withdraw it. And then later he understood, after seeking counsel from other lawyers, fellow colleague lawyers, is that if he withdraws, then he cannot even appeal this matter. And even if this matter was dismissed, he had nothing to lose. In certain courts, yes, if you do not withdraw the matter and the matter is decided on the merits by the judge, there can be adverse consequences. Say if it's an appeal and the matter is premature, then the observation of the appellate court on the merits can hurt your case more than you just withdrawing the petition. In this particular matter, this lawyer and his client had nothing to lose but everything to gain by going on with the case. If they would have withdrawn it like they did, now it is very, very difficult for them to appeal the order of this court, because the order of the court only says, after some arguments, the counsel for the petitioner wishes to withdraw the present petition, dismissed as withdrawn. And if this person would have said, "All right, my lords may go ahead and dismiss it," the judges would have passed a reasoned order. But then after that, this lawyer and of course his client would have had two opportunities to appeal against that order before the appellate courts. And because of that, when he later realized it, he expressed his inability to go about pursuing this matter. The only now remedy available before him, which is also not something which is a sure shot 100% thing which is definitely going to happen, is to file an application for recalling the order of the court whereby it dismissed the matter as withdrawn, and then to say that the matter may be decided on the merits. There have been some occasions where this has been done and the judges have not imposed any cost, but more often than not, if you pull a stunt like this, that after you withdraw the petition, then you file an application for recalling the order, blaming it on the previous lawyer, in all probability some cost will also be imposed, which is what this person's client is also now going to risk when he moves the court for recalling of the order of the court. Another example is, at a certain point of time, I sent an associate several months ago to a court to seek an adjournment citing some grounds. The associate made those submissions and then the judge says, "All right, then what else remains in the matter?" The associate, fresh off the boat, had no idea about anything and said, "I don't know." The judge says, "This is already done, so should I just dispose of your matter?" And the associate said, "Very well, my lord. My lord may do that." And then the judge throws the file and says, "Call your senior." So the senior is called, he drives all the way to the court, and then he is informed by the court that the associate almost got your matter dismissed. And of course, the judge was playing around, mocking the associate and trying to teach that associate an example. However, there are far greater consequences that I have seen other people also suffer when they make a submission before the court that they are not sure about. Say, for example, the judge again says something like, "You dismiss, or you withdraw, or we are going to dismiss," or something else, perhaps such as what kind of granting a maybe longer adjournment, or perhaps disposing of the matter on a mutual statement of the parties, which has not been approved by the client. Then it again becomes a problem. So a lot of situations, it is far better to just tell the judge that you don't know what is being talked about, and instead just tell the judge that yes, I am here, either my lord can teach me himself or herself, or I will go, my lord may pass over or adjourn the matter, I will go and ask other people, and then I will seek instructions from, and you don't say I will ask other people, you say I will seek instructions. Those instructions could be from your client, which ideally means your client, but that also means that you will also understand this point from another colleague of yours, and then you will go back into court, and perhaps hopefully you will be better equipped in dealing with this situation. Save yourself the embarrassment. The greater embarrassment, the greater evil you have to forego by telling the judge right there and then you don't know what's being talked about. Instead, please give me a passover or an adjournment, rather than conceding to what the court is saying anyways, or conceding to what the other party is saying anyways, without understanding in good detail the consequences of your actions.